The Catholic school counselor who had sexual intercourse with a teenager, including, by the way, in her office, has just accepted her responsibility in this sordid tale. But what happened and what could her punishment be? Let's talk about it. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Okay, we have another teacher in the spotlight for having sexual relations with a student. Now this time, we actually have her admitting it and pleading guilty to it.
Did you engage in sexual conduct with a 17-year-old male on those two dates?
Yes.
So that is 43-year-old Emily Nutley. She's the former director of academic services at the private all-boys Catholic school known as St. Xavier High School out in Cincinnati, Ohio. And she just pled guilty to 2 counts of sexual battery for having sexual conduct with a 17-year-old male. These are third-degree felonies. She faces up to 10 years in prison. This was accepted by the court. And it's interesting, and something that we're going to talk about a little bit later, is she was originally facing 6 charges, so she pled guilty to 2. We'll talk about how that deal might have happened. But in what has become so familiar, listen to this progression as laid out by authorities. So what started out back in 2023 of Nutley beginning to text this teenager after school hours, this would go into 2024, and it involves sending nude photos, sexually explicit messages. That escalated into them engaging in sex acts, and then it escalated once more with the pair ultimately having sex. And at least one of those episodes actually was in her office. Yeah. And it wasn't just criminal charges that Nutley faced. No, she lost her job. This happened after the school did its own private investigation. Apparently, it was that investigation that sparked the criminal investigation. But you're talking about somebody who lost her career. I mean, she claimed in court that she is an 18-year veteran in school counseling. So it appears that's over. And her husband filed for divorce after the charges were announced, after they were filed. This is a mother of 3. Her life is essentially ruined. And so when her sentencing happens, currently scheduled for June 10th, not only could she face prison time, but she's also not allowed within 1,000 feet of a school, and she's going to have to register as a sex offender. So there's a lot of different elements to this. I want to discuss it more. I want to discuss more about the case and also what we can expect for Ms. Nutley's sentencing. So let me bring on special guest, prosecutor, former Deputy Attorney General of Ohio, Mark Weaver. Mark, thank you so much for coming on. Appreciate you taking the time. So first of all, before I get into your experience with this and these kinds of cases, somebody might be looking at this and saying, wait, I don't understand. 17 years old? That's older than the age of consent in Ohio. Why is this a crime? Talk to us about why this is a crime.
Yeah, there are different flavors of sex crimes with children in the criminal statutes of Ohio, and you can only charge based on the age based. Under 16, it's a lot easier to get some of the other cases like gross sexual imposition. Under 18, but over 16, you can get sexual battery, which is what was charged in this case. So every time we prosecute a sexual offense involving children, we have to do an analysis of how old was the child when the sex act happened and how old was the perpetrator, and then that helps you pick the right statute.
And I think here it's because she works at the school and the victim is a student, right? That power dynamic, and I read the law there on it, that's what, and it's not the first state I've seen that. There are certain categories where you have that power dynamic where it is a sexual battery. Why is that the law?
Well, first of all, there are ways to get these convictions if the perpetrator is older than 5 years than the person who's the child, and that person's under 16. That wouldn't apply here because the victim's not under 16. But our legislators have decided that when you're in a position of power, you have a special duty. It sounds crazy. A special duty to not have sex with children. I think, now I'm a prosecutor, I maybe have a different take. I think all adults have a special duty not to have sex with children, but there's an extra super special duty for teachers or people in authorities, or in cases, one of the cases I recently prosecuted, a coach. And these people have great sway over these young victims.
It's interesting you say that because the statute actually says that this would be an offense if the offender is a teacher, administrator, coach, or other person in authority employed by or serving in a school for which the Director of Education and Workforce prescribes minimum standards if the other person or one of the other persons is enrolled in or attends that school and the offender is not enrolled in and does not attend that school, meaning they're not a fellow student. So talk to us about, you said you've had similar experiences prosecuting similar cases.
Yeah, I've been prosecuting child sex cases since 2001 in a part-time endeavor. I do other legal practice as well, but here in Ohio, there's a part-time prosecutor position, which I've had for all those years. And most recently, and some of your Law&Crime viewers probably have seen the coverage of this, I prosecuted an Ohio couple, a man and a wife. She was a cheerleading coach. He was and a substitute teacher. He was the wrestling coach and a teacher. And they were conspiring so that he would direct his wrestlers to have sex with his wife. And then she and he would share the details about it afterwards in a very sick fashion. And it happened numerous times over several years with a victim as young as 13. So recently just ended that prosecution. They were convicted. They're now both in prison.
Hey everybody, this is a Law&Crime legal alert. Did you know that children are being diagnosed with serious conditions like type 2 diabetes and non-alcoholic fatty liver disease, and the research is potentially linking ultra-processed foods to all this? Yeah. Well, Morgan & Morgan is stepping in to fight to hold these food companies accountable. With decades of experience fighting large corporations, they are ready to stand up for the families who deserve justice. So if your child under 21 has been diagnosed with type 2 diabetes or fatty liver disease, then visit www.forthepeople.com/food or scan the QR code on screen to learn more. Yeah, that's pretty unbelievable and disgusting, to say the least. But let me go back to the Nutley case for a second. So she was facing 6 charges. She pled guilty to 2. Sounds like a good deal for her, right? But what would be the incentive for the prosecutors to offer this?
We face this all the time. And I'm not an elected prosecutor. I don't ever want to run for office, but I talk to a lot of elected prosecutors, and they get weary of people attacking them in election time, saying that they're soft on child sex cases, when what we've done typically is talk to the victim and see how zealous or interested they are in actually testifying in open court in front of a bunch of strangers about a sexual act that they participated in. Most of these victims are simply uninterested in doing that. Now, we can subpoena them to make them testify, but that's a bad look and a bad motivation for a witness. So when the victim is willing to forego any trial and not have to testify and get a guaranteed conviction with no appeals, unless there's something wrong in the sentencing process, this woman will not have appeals because she's pled to it. And so when a victim hears that, well, I don't have to testify and talk about these embarrassing details, we'll know for sure that she's guilty and everyone will know I'm correct, and there'll be no appeals and I got some certainty. That's very attractive to a victim. And so we as prosecutors are willing to dismiss some of the felony counts in return for the defendant pleading guilty some other felony counts.
And does it also signify to you that Nutley and her defense counsel believe they didn't have a good defense going into this?
Yeah, I've never been a criminal defense lawyer, but I have many friends who are, and I talk to them all the time. Their calculus, even though they have no burden of proof, their calculus is, man, if we get convicted on every one of these counts and the judge decides to max and stack those counts, you will be spending certainly the prime of your adult life in prison, and maybe even well into your senior years. And even for women, sex offenders are poorly treated in prison, and these defendants know that.
And because so much of this seemed to be documented through a phone, right? I mean, how many cases do we see? It's the text messages, it's the sexually explicit messages, and even if there wasn't sexually explicit messages, if you have the phone that would show that you were in contact with this person and you were together and you were planning up a meetup or whatever it might be, that is, I just don't know how you go into this case and say something didn't happen when, according to this statute, it's a very low bar to convict her on this.
Yeah. There's something else that your viewers outside of Ohio probably ought to know. This school, we call it St. X in Ohio, is an elite Catholic boys' school. In Cincinnati, Catholic men often will meet each other, and the very first question they'll ask is, which of the 2 competing high schools did you go to, one of which was St. X. And so this is an elite school that everyone in this area knows. And this woman was the head of the counseling program. So you can imagine the stakes were very high, and the prosecutors wanted to get this right. And one way to get it right is to get a guaranteed conviction.
By the way, why did this happen? Why did this deal work out literally right when the trial was supposed to start. Does that happen? They plead guilty like literally at the 11th hour?
It's a smart question. I know you're a lawyer, and maybe your viewers know you're a lawyer. That's a smart question. Here's probably what happened. This judge, Judge Branch, has a more relaxed policy about pleas. I've appeared in many courts, and I've prosecuted cases in 12 different counties in Ohio, where the judge will say, "There's no pleading just before the jury trial unless you're pleading to the indictment," which means because the judge can never stop you from pleading to the indictment. But if there's going to be a deal, and I've got a jury panel coming in for voir dire ready to talk, no, you're going to trial. So this judge, they probably felt her out and talked to her a little bit, both sides, of course, the defense and prosecutor, to see if she'd be willing to take a plea that close to trial on reduced charges. I'm here to tell you, and I felt this pain, not every judge will.
So when you say that, that means if she wanted to plead guilty to all 6 charges. I call it a deal, but it's not really a deal in the sense that the prosecutor didn't agree on a prison time or didn't agree on a sentence, right? That's going to be up to the judge. Is that typical? Hey, listen, we'll drop the other 4 charges, right? You'll plead guilty to 2. It's not in our control what the sentence will be. I think it's 1 to 5 years for each charge. Is that typical that the prosecutor either will not or cannot guarantee what the sentence will be?
It is, and we call this a free to argue. Sometimes, as part of the deal, there will be a stipulated sentence, but the judge doesn't have to take it. So in Ohio, they also, the local municipal court judges can appoint a litigator to sit on their docket when they're on vacation or on training. So I've done that for many years as well. And so when I'm sitting, and never on cases that I prosecute or even counties where I prosecute, by the way, but when I'm sitting as a judge and there's a deal like this, I will look right at the defendant and I'll say, now, even though you pled guilty, nobody can change the fact that I have the last say on what your sentence will be. And if they say they don't agree with that, then I withdraw their guilty plea and we go right back to a trial, because the judge has the final say on the sentence. And the best lawyers can usually get is a backdoor in chambers agreement from the judge of what the range is or what they're likely to do. But the sentencing is always the province of the court.
What is she looking at a potential sentence here? Is she looking at probation? Is she looking at prison time? How long would this be? And also, if you can, I mean, what are the arguments you're going to hear from both sides?
Yeah, here's what's happening as we speak. The judge has ordered a probation officer to fill out what's called a PSI, or pre-sentence investigation report. And this probation officer will talk to the victim and the victim's family, talk to the defendant's family, talk to other people in the community, maybe her former boss, people who worked with her. She's also no doubt amassing letters and character witnesses to appear at this sentencing. At the same time, the victim is being told that he has the ability to give a statement in court or have it read by the prosecutor, or he can mail it to the judge, however you'd like to do it. Each side is preparing a case for, in her case, leniency, probation, or what we call community control in Ohio, or on the prosecution side, some period of time. Now, she gets more appellate rights if the judge maxes her on both counts. So a lot of judges maybe will come in just under the max. So maybe you might see 4 years on each, and then the judge would have to decide whether that's going to run concurrently or consecutively. And the judge has to make a series of findings on the record at the sentencing hearing that the purposes and principles of felony sentencing in Ohio have been met. And what are those purposes and principles? Well, people who've never been convicted of something before are supposed to get a less serious sentence than somebody who has been convicted of. We have no reason to believe she's been convicted of anything. I've seen nothing in the coverage that she has a previous record. That weighs in her favor. The victim can make a big difference here. If this victim comes in and minimizes what she did and said, listen, I was a willing participant, I'm almost an adult, I'm just as responsible as she is, that could result in a slightly different or lesser sentence for her.
Oh, I was going to ask you that. If the victim, and I have no reason to believe that the victim in this case would do it, but just for argument's sake, if the victim comes forward and releases a statement and says, I want this read at court, and it minimizes what she did, defends what she did, again, just for argument's sake, does the prosecution have an obligation to present that nonetheless?
Oh, yeah. So we have a state constitutional amendment. It's in our Constitution that a victim has an absolute right to be heard in court. Now, when I have my victim going in, I will work, it's almost always a female, but in some cases it's a male, but I'll work with her to help her shape her statement as long as it's her own voice. I'll usually say, write down what you want to say, and then let's talk about it. And then I might make some suggestions, but it's completely up to that victim what they want to say. And nobody, not even the judge, can stop them. And I defy a judge in Ohio to shut down a victim in the middle of a victim's statement because it's a constitutional right. That judge will be overturned and potentially disciplined for violating the Constitution if they were to shut down what a victim wants to say.
And again, not to suggest that this teen would do this, but because Fox 19 reports that at one point this teen tried to stop the relationship. Nutley wouldn't have it, kept on texting him. So, nothing to indicate that you would say a sense of sympathy on the part of the victim if they release a statement for the court. But generally speaking, I mean, what do you think her sentence is going to be for something like this?
Well, this judge is known as a little more liberal on sentencing than some other judges on the bench. I'd like to think she'd send this woman to prison. In the case I told you about, where the wrestling coach and the cheerleading coach were conspiring to have children have sex with the wife, in my sentencing memo, I filed I think a 12-page sentencing memo in that case. One page was devoted to all the popular movies, TV shows, and songs about young boys in their teens having sex with a teacher. There's a rock and roll song called Hot for Teacher. There's been movies dedicated to this. There's been TV shows. I actually listed them. It'd be more interesting reading than most sentencing memos are, because I, summarized the plot and the year and the stars and that sort of thing in it. But I was trying to make the point that the culture in some way glamorizes teenage boys for having sex with adult women. And that's just wrong. It is every bit a crime as when a female adult has sex with a teen boy as the reverse. And it needs to be treated that way. I hope this judge will treat it this way. This person needs to go to prison. She needs to be a tier 3 lifetime registration sex offender. She'll never teach again or be a guidance counselor again. That's easy. Her certificate will be revoked by the Department of Education. But we need to send a message to teachers that don't even think about this. Stay well away from sexual conversations of any sort with a child. No teacher or counselor should be speaking about sex to a child unless the parents are involved in that conversation.
And having sex with the child, nonetheless.
Well, of course, but that's true.
What is a tier 3 sex offender?
So we have 1, 2, 3. 1 is the lowest level with a much shorter period. I think a 15-year. 2 is 25-year. Tier 3 is life registration. Tier 1 does not require your neighbors to be notified that you're living near them. Tier 3 does require for the rest of your life your neighbors to be notified. There's more frequent reporting times for tier 3s. It's the most serious. It's what I've asked for. One of my early child rape cases 20 years ago was a father who raped his 2.5-year-old daughter. That's the sort of thing I asked for in even those most serious cases.
Ugh, that's horrifying, to say the least. When you look at this, when you look at her position, you talked about a little bit, all boys school. Her job was to help the kids that were struggling. In fact, Hamilton County Prosecutor Melissa Powers had said this child was in need of help and guidance, but instead found an adult looking to act out her perverted sexual desires. That is an aggravating factor, right? And I feel like that places her in a very unique position of abuse, to abuse, I should say.
It does. Remember, a counselor, particularly in an elite school that is funneling these kids to what some people call the elite universities of the country. We could certainly argue about what's elite or not, but these kids are on a upward path to success. If for no other reason, this fraternity I've told you about, kind of an old boys network amongst the alumni, that counselor has the ability to make sure you get better recommendations. That's a significant amount of power. Maybe even more than a teacher, because your math teacher can only give you 1 grade in 1 class. But your guidance counselor has a much bigger effect. It seemed from the facts as reported that this guidance counselor was having her own needs served and in some way was felt vindicated or validated by having sex with a young man. I don't know what's going on in their personal life. This divorce probably reflects that. It could also reflect the husband trying to step away from her ahead of any civil lawsuit that may come and to sever the liability chain. Not quite sure which, if it was or both. But she has tremendous power in his life, tremendous influence in her life. We want our counselors to help our kids get through this rough patch of high school. I remember being very appreciative of my daughter when she was in high school, and her counselor was so kind to her and wrote her such a nice recommendation and encouraged her that I reached out to that counselor afterward and told her how appreciative I was as a parent that a counselor would play such a big role in my daughter's life. That's what we expect from counselors. This woman failed well short.
Mark, you mentioned a little bit, you've covered these kinds of cases. What drives somebody to do this? Obviously, it's impossible to get into somebody's head, but in the cases that you've seen, the cases you've covered, the cases you've prosecuted, do you see an underlying theme, or what are some of the reasons people do this?
Yeah, I wasn't prosecuting in the 80s or 90s. I wasn't even a lawyer, until the 90s. But there's no doubt that the internet and social media and the availability of sexual content online is a driver of nearly every one of these cases. I have not had a sex case in the last several years that did not involve either cell phones or naked photos or social media or porn. When I prosecute child porn cases, I'm finding my defendants having hundreds, sometimes thousands of images that were downloaded in seconds. Um, there was child rape in the 1900s. Of course there was. There's been this sort of sin and crime since humanity started. There just wasn't the access to the sort of image that make this seem sexually attractive. If you read any story about why the online porn business is in such a risk for kids, is that there's entire categories of porn called barely legal, where the girls who ostensibly are 18 or older, I think they have to prove that somehow, dress up like they're not, and dress up like they're in junior high or maybe even younger, having a lollipop and dressed in a very childish outfit. There's lots of online pressure and access to resources that suggest this is just another sexual fantasy that needs to be carried out. And so we've lost our true moral north in matters of sexual ethics. The society is reeling from it, and we're seeing children being victimized as a result.
Oh, it's like quite nauseating, to say the least. Back in 2024, when this was going on, St. Xavier High School President Tim Riley released a statement. And the statement said, "We appreciate the unwavering commitment of our faculty, staff, and administration to the safety, well-being, and dignity of every student entrusted to our care. We believe this case to be an isolated incident. However, if any St. Xavier employee has failed you or someone you know in this regard, we strongly urge you to contact the Springfield Township Police Department, Child Protective Services, or reach out to either President Tim Riley or Principal Dan Lynch, or by phone," and all of those numbers were listed. "At this time, we respectfully ask for continued prayers for the well-being of our students, their families, our entire staff, and for all individuals impacted by abuse. We remain committed to providing a safe, supportive, and nurturing environment for our entire St. Xavier community." Mark, I ask this question every time. Is the school in trouble? Do they need to make a change? Or is this one of those cases, how do you predict something like this? 18-year veteran, she does something like this. How do you know?
Yeah. As I told you, my prosecution endeavor is a part-time one. And as part of my other practice, I often defend school districts when they're sued. Never in the same cases, of course, that I prosecute, nowhere close. But my experience has been most schools want to get it right. Most people in K through 12 education and higher education got into it to help people achieve. My mother was a principal her whole career. It's one of the proudest things that I have to say about her. She was an outstanding principal, taking care of little kids, and that was her life's joy. And so when this does happen, and I've sat with superintendents and board members and talked about these sexual offenses, they're mortified. They want to keep kids protected. I've never heard a bad thing about St. X and its protection of its students. Now, I'm not from Cincinnati. I live in the Columbus area, and so I'm not tied into that network. But I know lots of alums of St. X. I've never heard a word about this. It sounds like it probably was an isolated incident. Having said that, I would not be surprised at all if this school were sued in a civil case for negligent supervision or for creating an environment where there weren't enough safeguards to protect this boy. And as you know, and your viewers might know, 99% of civil cases get settled out of court. So if they get sued, it's likely there would be some insurance payout from the school to the student. And this is not a public school, so there are no public records. That settlement would likely be confidential.
Mark Weaver, Thanks so much for coming on. Thank you so much for breaking down every single detail of this case. And more importantly, thank you so much for the work that you do and have done. It is very well needed and appreciated.
Sidebar is doing good work by bringing the public more details about this. So thanks, as always, for your invitation to appear, and I look forward to seeing you next time.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.